Gail Davidson, and Gail will be speaking about Canada's duty to protect human rights abroad, the case of Omar Khadr.
I want to thank each and every one of you for coming to listen to this talk today, because the Omar Khadr case touches on an issue whose importance goes far beyond the very critical nature of the Omar Khadr case. As you all know from the law studies you've done to date, Canada was much more involved than our size warrants in the development of the international human rights and humanitarian law that has taken place since 1945, since World War II. The Omar Khadr case sadly reflects a trend in the opposite direction of Canada being involved in the dismantling of human rights law. And so it behooves all of us. I don't know if all of the people here are law students, but it behooves law students, lawyers, law professors, and citizens to get involved in the critical issue of the dismantling, the sort of post-9/11 dismantling of human rights. Now, today what I want to do is I want to talk for 35 minutes and then leave the matter open for questions from you people, questions and comments from you people. So today what I'm going to do is I'm going to divide the comments I have up into a number of categories, but before I tell you what those categories are, I want to just tell you that James Richardson over here has a petition that he's going to be circulating. This talk is part of a Pan-Canada week of action for Omar Khadr, October 5th to October 11th. There's many events and information and bulletins posted on the website, which is www.bringomarhome.ca. One of the things that I just sent for posting yesterday that might be of interest to all of you is Omar Khadr's Canadian lawyers, Edmonton lawyers Dennis Edney and Nate Whitling, have filed an application in the Federal Court of Canada that will be heard on October 28th for an order for mandamus, for an order compelling the Canadian government to take action to secure Mr. Khadr's release from U.S. military custody and repatriation to Canada. And I sent their memorandum of argument for posting to the Bring Omar Khadr Home website yesterday, so I'm sure that it's up there and you might want to take a look at it. When I'm going through my comments, I just want to tell you about that brief, though. The Canadian lawyers have restricted their brief to Canada's duty under the Canadian Charter of Rights and Freedoms. The remarks that I'll have to you for today, I'm not going to be talking about the Charter at all. I'm going to be talking about Canada's duty to act to prevent and punish violations by a foreign state of the internationally protected rights of a Canadian citizen wherever those violations occur, and how the facts in the Omar Khadr case have triggered that duty. And I'm going to talk about that duty as having two aspects to it. Number one is the duty to take, the government duty to take all available legal and diplomatic steps to prevent further violations, and to take effective steps to investigate reported and apparent violations of internationally protected rights, both violations by both Canadian officials and foreign officials, and to conduct the prosecutions called for by those investigations. In my talk, the way it's described in the poster is posing it as a question. I'd like to tell you at the beginning that my conclusion is, without a doubt, that Canada has a duty to do both of those things, and the facts and the law in the Omar Khadr case are such that, in my opinion, Canada is not only obliged to provide, to attempt to provide diplomatic protection to secure Omar Khadr's release from U.S. military custody and repatriation to Canada, but they're at this point, given the decisions of the Supreme Court of Canada and the Federal Court of Canada, they're now obliged to conduct investigations not only of the actions of U.S. officials, but also the actions of Canadian officials from the Department of Foreign and International Affairs, DFATE from CSIS, and from the RCMP in complicity and participating in the violation of Mr. Khadr's rights. What I'd like to do is start with a brief overrun of the facts surrounding Omar Khadr. I'm sure you know many of them. He was captured July 27th, 2002 in a small village in Afghanistan after a 5-hour air and ground firefight by U.S. troops who were at that time, who in October of 2001 had illegally invaded Afghanistan and were still there carrying out their military operations. Now, that was 4 hours of air bombing and 5 hours of ground assault, and at the end of that, the only person still alive was Omar Khadr, who was at that time 15 years of age, and he was taken into custody by the Americans. At first, he was kept in custody at Bagram Air Force Base, which is a notorious prison, and he was, one of his interrogators there was a sergeant called Sergeant Claus. Sergeant Claus is a U.S. military, a member of the U.S. military who was prosecuted in the death of one detainee and injuries to other detainees, the death and the injuries having been caused by the torture that was used by Sergeant Claus. Around the end of October, Mr. Khadr was transferred to Guantánamo Bay prison, and so since the beginning of November, end of October of 2002, Mr. Khadr has been a prisoner at Guantánamo Bay. For the bulk of the time that he was in Guantánamo Bay, he's been kept in the most severe circumstances. He's housed in a 6-foot 8-inch by 8-foot cell. He's been kept largely in isolation for the past 6 years, and he's been subjected to a wide variety of torture and other inhuman and degrading treatment and punishment. Now, instead of going through that, that's the verbiage that I just gave you from the Convention Against Torture. For the rest of this lecture, I'm going to simply refer to the treatment as torture, and there's a couple of reasons I'm going to refer to it as torture, because in fact, the Convention Against Torture and the Geneva Conventions and various Canadian statutes that were enacted to ratify the Geneva Conventions, the Convention Against Torture, and the Rome Statute all prohibit both torture and other degrading and inhuman treatment and punishment. That's one reason I'll just use the word torture. The other reason that I'll just use the word torture is one of the strategies of the U.S. when deciding to use enhanced interrogation techniques is that whenever anybody said, oh, just a minute, these enhanced interrogation techniques are torture or tantamount to torture, they would say, no, we don't torture anybody. We never torture anybody. What we do, in fact, is we treat them humanely. These are just enhanced interrogation techniques. So there got to be a very Mad Hatter's Tea Party sort of discussion going on, saying that perhaps when was waterboarding torture and when was it not torture. Anyway, some of the treatment that Mr. Khadr was subjected to ranges from short shackling. That's where the prisoner's wrists are shackled together, their ankles are shackled together, then both the wrists and the ankles are shackled to a little U, a metal U that's in the cement floor, and then they're left there for long periods of time. So in addition to that, he was subjected to a wide range of other torture, including force feeding when he had gone on a hunger strike, what Senator, then Secretary of Defense Rumsfeld called environmental manipulation, which is extreme cold and extreme heat in his cell, and deprivation, including sensory deprivation, having the light on 24 hours a day, not having the light on, threatened rape, threatened rendition to countries where he would be further tortured, and so on. I'll restrict my comments about the treatment of Mr. Khadr, though, to the treatment that the Canadian government officials were given specific written notice of. And that occurred in March of 2004, and this was confirmed by the federal court. The Department of Foreign Affairs, CSIS, and the RCMP visited Mr. Khadr. First of all, let me back up a bit and say when Mr. Khadr was taken into custody in Afghanistan, the Canadian officials were notified of it, so they asked to have consular access to Mr. Khadr. Now, that's a right there's a Vienna Convention on Consular Relations that means that whenever one country takes the national of another country into custody on a capital crime, they have to give notice to the country and allow consular access so the country whose national it is can visit the person and ensure that they're having proper legal representation. And there's a number of cases in the International Court of Justice establishing what happens when the country that's captured the person refuses to give, refuses the country the ability to give consular assistance. And there's a case called Avena coming out of where Mexico took the U.S. to the International Court of Justice. And the remedy, says the International Court in that case, was that the decision that the court had arrived at, whatever court in the holding country's jurisdiction, had to be reviewed if consular access hadn't been provided. In any case, the U.S. refused to provide Canada with consular access. Mr. Khadr was taken to Guantánamo Bay, and the Canadian government started assuring Canadians. This is also a story of Canadian government secrecy and lying, a combination of the two, secrecy, lying, and bungling. I guess we have the three of them, but the secrecy and the lying are much more troubling than the bungling, because the bungling might have been avoided if there hadn't been the secrecy and there hadn't been the lying. In any event, the Canadian government, obviously, at the time when they were saying to Canadians, to Amnesty International, and what few Canadians were concerned about Mr. Khadr at that time, because even lawyers and law professors in Canada at that time were saying, well, his family really wasn't very nice. And, perhaps there is some forgetting, of course, the presumption of innocence and the fact that Mr. Khadr was a child and the fact that he'd been illegally captured and a number of other factors. Anyway, CSIS and DFATE and RCMP decided with the Americans that they would visit Mr. Khadr in Guantánamo Bay and they would interview him. And they did interviews in February 2003, September 2003, and March of 2004. And they didn't do any interviews after that because Mr. Khadr's Canadian lawyers, Dennis Edney and Nate Whitling, took an application to federal court where the justice in the federal court prohibited the federal government from making any other visits to Mr. Khadr. The federal government had tried to characterize the visits as welfare visits, and Mr. Justice, I think it was Van Finkelstein, totally rejected that characterization and said they weren't to visit him anymore. In any event, before the March 2004 visit by Mr. Gould from DFATE, the U.S. advised Canada that in order to prepare Mr. Khadr for the interview by the Canadian officials and make him more amenable to speaking to them and responsive to their questions, they had subjected him to one of the enhanced interrogation methods approved by Senator Rumsfeld, which was adjustment, I think they called it adjustment of sleep schedule, but the interrogators themselves had a more affectionate term, what was called the frequent flyer program. Now, the UN Special Rapporteur on Torture and four other rapporteurs who filed a report with the UN in 2006 on Guantánamo Bay said that sleep deprivation under the frequent flyer program, I'll tell you what that is in a minute, of several consecutive days was certainly was tantamount to torture. What they did to Mr. Khadr was a little more than that. For a period of 21 days, they moved him every 3 hours to ensure that for a period of 21 days he wouldn't be able to sleep properly. And the Canadians, knowing that, went ahead with the interview in any event. So those are some of the facts. Now to quickly tell you about Canada's duty and what instruments that flows from, the international and the domestic instruments that flows from. Well, Mr. Khadr's been in Guantánamo Bay pretty well. All of his international rights have been violated. His right to freedom from arbitrary detention, his right to freedom from torture, his right to access to have his rights determined by an impartial and independent judge, his right to a fair trial, his right to due process, his right to legal counsel, and so on and so forth. Now, many of the violation of many of those rights are crimes in and of themselves. And several of those rights that have been violated are rights that are considered in international law to be non-derogable rights. In other words, they're rights that can't be taken away from a person, even if their family isn't very nice, even if they happen to be Muslim, because I think that Mr. Khadr's racial and religious background is certainly a factor in the way that Canada has responded so far to his treatment. And in that regard, I just want to tell you as an aside that every other Western country that had a national in Guantánamo Bay secured the release of their nationals a long, long time ago, Australia being the most tardy, but we wouldn't want to be following Australia's example of the past anyway in very many things. So to give you an example, Great Britain secured not only the release of all of its nationals, but all of its permanent residents that were in Guantánamo Bay. Sweden, Spain, England, France, Denmark, were all countries who had nationals in Guantánamo Bay, and they secured the release of those nationals a long time ago. So Canada's duty, to the question that I want to put to you today and answer also from my opinion, of course, is whether Canada's duty to prevent torture, which is a non-derogable right, to prevent denial of access to an independent and impartial tribunal or judge, which is also a non-derogable right, to prevent arbitrary detention, which now is certainly being talked about as a non-derogable right, whether the duty of Canada, which exists under a wide number of statutes in Canada, whether that stops at the border. Now, the international instruments that Canada's ratified that establish those rights, some of them are the Convention Against Torture and the International Covenant on Civil and Political Rights and the 4 Geneva Conventions. All 3 of those statutes require the country ratifying the statutes to ensure protection of the rights wherever, to ensure protection against violation of the rights wherever they occur. So to meet that duty, Canada has passed legislation which gives Canada universal jurisdiction to prosecute violations of rights, breaches of the Geneva Conventions and violations of the Convention Against Torture wherever they occur. And whatever the nationality of the person is that is alleged to be perpetrating the violations. Canada's universal jurisdiction is what I would call a conditional universal jurisdiction, so it needs a trigger. And one of the triggers to Canada's universal jurisdiction is if the victim is a Canadian citizen. So, of course, the the trigger, there needs no other trigger because Mr. Khadr is a Canadian citizen. Now, I wanted to deal with the issue of Canada's knowledge of the violations of Mr. Khadr's rights, especially in view of the fact that Canada has always taken the stance that there's two responses that the Canadian government has had, and this is the Canadian government under Jean Chrétien, under Paul Martin, and most recently under Stephen Harper. There's two responses that they've had to why they're not intervening to assist Mr. Khadr. And they really are not intervening in a way that's completely different than other countries. So if I could just tell you that Canada, Mr. Khadr's case, along with other Guantánamo Bay detainees' cases, has come up. They've made attempts to have habeas corpus before U.S. courts and before the U.S. Supreme Court. Mr. Edney and Mr. Whitling asked the Government of Canada to file an amicus brief with the U.S. Supreme Court. All other countries where their nationals have come up, the case of their nationals has come up before the U.S. Supreme Court, have filed amicus briefs. The Canadian government demurred. They said they didn't want to, so Mr. Edney offered to draft their brief for them if they had a personnel problem and they didn't have time to prepare the brief, and they didn't. Now, I want to also tell you that it isn't as though the Government of Canada doesn't provide amicus briefs to matters before the U.S. Supreme Court. So, for example, I think it was in 1998, there was a chap called Falder who had been convicted of the murder of a woman in Texas, and he was on death row. And Canada was wanting to have the decision to convict him and the decision to sentence him to capital punishment reviewed on the basis that the U.S. had failed to allow Canada to provide consular access to Mr. Falder, probably in that case because they had failed to advise Canada of the Mr. Falder's, the charges against him. In any case, on that occasion, naturally, Canada provided an amicus brief to the Supreme Court. So the two stances of the Canadian government is, number one, Mr. Harper recently said, well, Mr. Khadr's charged with very serious offenses and he must go through the due process available to him in the U.S. He also tagged on to that saying, of course, Canada is continuing to make sure that Mr. Khadr is being properly treated. So that's a pretty breathtaking statement in view of the fact that we know that Mr. Khadr has never been afforded any treatment that is legal, let alone decent. The second reason that the Harper government and the Martin government before him has given for not intervening is Mr. Harper has said, well, Mr. Khadr is a sort of comity of law argument. He said Mr. Khadr has to exhaust the remedies available to him in the U.S. and the U.S. processes before Canada can intervene. Now, when Mr. Harper said this to Lawyers Against the War in the summer of 2007, at that time we'd sent him a letter that had been signed by law professors from around the world. And so we said, well, we have that letter was only signed by 40 people and organizations, but we said, well, we have this large group of people to draw on who are happy to come to Ottawa at their own expense to advise you of the facts and the law, because we know by your statement to us and statement to the press that you're misapprehended about both. And I think it was Mr. McKay was the then, no, would it have been O'Connor? I can't remember. They've been going through, oh, no, he was defense. I can't remember anyway. They were all too busy. And so that couldn't be involved. So that couldn't be done. So as to the first Another one of Mr. Khadr's rights that's been violated, that's a non-derogable right, is the right to be right to freedom from ex post facto prosecution. So Mr. Khadr is charged right now with a number of charges. He's charged with murder as an unprivileged belligerent. He's charged with attempted murder as an unprivileged belligerent. So in other words, what that is they're saying that the U.S. soldiers who were bombing by air and using firepower by land against the compound, they were privileged belligerents. And Mr. Khadr, as the recipient of this behavior, was an unprivileged belligerent. So those are those two charges. Another charge is of spying, and providing spying on the U.S. and providing that information to Al-Qaeda and others hostile to the U.S. Another charge is conspiracy with Al-Qaeda, and the conspiracy that the current charge, because there's been 3 sets of charges laid against him, the current charges allege him being involved in conspiracies going back to, I think, 1996, when Mr. Khadr would have been about 10. So in any event, and then the last charge is providing material support. And the providing the material support charge, these are all charges created by the Military Commissions Act, which was passed by Congress in 2006 in order to do an end run against a decision of the U.S. Supreme Court. And so they're all charges that were made up at that time. So they didn't exist at the time that Mr. Khadr was alleged to have committed them. So there's a good argument to be made with regard to some of the charges that they're ex post facto offenses, and therefore he has a non-derogable right to be free for prosecution for them. And there's I think, an indefensible argument to be made with respect to other of the charges. And now, I want to just run through very quickly the Canadian government stance. First of all, to say that Mr. Khadr has to go through the due process in the United States. There is no due process. There's no scholar, there's no law professor, there's no group of lawyers who have issued a statement saying that the Military Commissions Act is possible of doing justice. In fact, just recently, last week actually, this is the fourth, another of the U.S. military prosecutors prosecuting matters before the Military Commission Act tribunals quit. And he not only quit, but he offered himself up as a witness in the trial of another child, Mohammed Jawad. And his evidence is that the Military Commissions Act tribunals were not capable of providing justice either to the people accused or to whatever were the alleged victims of the crimes that were in question. And some of the particulars that he gave from his own experiences, he said that he was forbidden to give the defense notice of exculpatory evidence that was within his knowledge. Now, other prosecutors have quit for similar reasons. But in any event, the Military Commissions Act has been condemned by everybody, by NGOs and everybody, as being a farce and a sham, and not in any way complying with the minimum international fair trial standards. And also, it's good to understand that under the Geneva Conventions, depriving a person or of the right to a fair trial is in itself an offence, and that's also under Canadian law, under the War Crimes and Crimes Against Humanity Act, and under the Geneva Conventions Act is a crime. and or transferring a person into the custody of a party where they'll be deprived of a war crime. So, in any event, so that reason doesn't hold any, doesn't give Canada a legal justification. The other one that Omar Khadr has to exhaust U.S. remedies, that's a Comity of Nations argument that doesn't apply when a number of situations exist. So it doesn't apply when the remedies available to the person are futile, as they most certainly are here. And so I won't go any farther than to say that they're futile. And one of the indicators of their futility is in August, of the end of August, I think it was August 28th, a White House spokesperson reiterated the U.S. administration position that they reserved the right to hold forever, indefinitely, possibly forever, he actually said this, people designated as enemy combatants, notwithstanding whether or not the Military Commissions Tribunal found the people not guilty. So it doesn't really matter if Mr. Khadr went through this process and was found not guilty. The U.S. still maintains the right to hold him forever. Okay, so now to go through notice to Canada, other than the notice they got in March of 2004 of the illegality of the treatment being afforded to Mr. Khadr by the U.S. I'm just going to restrict myself. I won't bother going through because we don't have time to do that. How's our time? Because we don't have time to go through all of the UN reports. So I'll just go through the decisions of the Supreme Court of the United States in this regard and the Canadian courts. So dealing with the U.S. Supreme Court, in June of 2004, the U.S. made a decision in a case called Rasool versus Bush, and that was later renamed as Hicks versus Bush et al. The court ruled that deprivation of habeas corpus violated the U.S. law and U.S. Constitution, and therefore detainees were being held illegally. Now, you probably all know this, but how Guantánamo Bay got set up was on November 13th, 2001. President Bush issued an order that said that the U.S., because of the fact that they were threatened with terrorism, they reserved the right to hold any non-U.S. citizens indefinitely and outside the boundaries of the Geneva Conventions for as long as they wanted, and to try these people outside U.S. law. And so then his order made up the military commissions, and then he confirmed that order in February of 2002, and he designated Secretary of Defense Rumsfeld as the person who would designate people as being illegal enemy combatants, and so people that fit into a category. It was completely arbitrary, the designation. So I could say, well, James there, like he looks like a likely candidate, and that would be it. That would finish, done, it was over with. Then James would go off to Guantánamo Bay. Then as far as treatment is concerned, Mr. Bush decreed that the Geneva Conventions wouldn't apply, but his decree said prisoners would be treated as humanely as the exigencies of the war on terror allowed. So that was just a complete open door. And then what flowed, so these are the torture memos that I'm sure you've heard about. So the torture memos all start with that November 13th, 2001, and then they flow down a nice line from that. Then we got from Mr. Rumsfeld the authorized enhanced interrogation techniques, and went on from them. Okay, so in June of 2004, the Supreme Court said, no, sorry, you can't deny habeas corpus, because these prisoners were all denied access to U.S. courts, and the judges in the military commissions aren't independent judges, you see. So they said, oh, you can't do that. So the U.S. Then 9 days later, they created something called the Combat Status Review Tribunal. And that was supposed to review the, that would replace habeas corpus, so that they would be able to, people that wanted to have their enemy combatant status reviewed could go to the Combat Status Review Tribunal. Then on June 29th of 2005, the U.S. Supreme Court in Hamden versus Rumsfeld said that the military commissions created by the Bush Edict of 2001 lacked the power to proceed because its structure and procedures violate basically everything, they said, the Uniform Military Code of Justice and all 4 Geneva Conventions. So that was gone. So the U.S. Congress set about and passed the Military Commissions Act. You see, so at every step, the U.S. Took some other step to get around what the court had said. So when the court struck down the military commissions tribunals, they created military commissions tribunals under an act of Congress instead of under the presidential order. And then on June 12th of 2008, the U.S. Supreme Court, in a case called Boumediene and versus Bush, ruled that Guantánamo Bay's right to habeas corpus and to the right to pursue appeals in the Supreme Court of the United States, in the U.S. court system, I should say, couldn't properly be taken away by the Military Commissions Act. So you see, they did, the Supreme Court did away with combat status, the legitimacy of combat status review tribunals, a presidential edict, combat status review tribunals, the military commissions created by a presidential edict, and the denial of habeas corpus via the Military Commissions Act. And still the U.S. is continuing to carry on and deny habeas corpus to people in Guantanamo Bay. Now, the decisions, as you know, in the Canadian courts in August of 2005, Justice von Finkelstein in the federal court decided that, ruled that the conditions at Guantanamo Bay didn't meet Canadian standards. That was all that he ruled at that time. And then subsequently the federal court ruled that Canada had to produce the documents that they had, documentary evidence of the interviews they'd conducted with Mr. Khadr to Mr. Khadr's lawyer, because they might be germane to his defense. The government of Canada appealed that decision, and that decision, that appeal went to the Supreme Court of Canada, and the Supreme Court of Canada heard that decision, and the decision of the Supreme Court of Canada came down in May of 2008, and at that time the Supreme Court of Canada said, and I don't know that Supreme Court of Canada has said this about any government before, the regime providing for the detention and trial of Mr. Khadr at the time of the CSIS interviews constituted a clear violation of fundamental rights protected by international law. And the Supreme Court of Canada concluded that participation by Canadian officials with the Guantanamo Bay process was, quote, contrary to Canada's binding international law obligations. And the Supreme Court ordered the production of those documents to the federal court. Now, that was how we as Canadians learned that Canada had been informed that the U.S. had subjected Mr. Khadr to the frequent flyer program in order to soften him up for the Canadian interviews. What happened with those documents is they were produced by the government to the federal court in their redacted form, and the lawyers contested the redactions, and so the judge in the federal court revised the redactions, and that's how we learned of that behavior. So all of those courts, 3 courts in Canada and 3 courts in the United, 3 Supreme Court decisions, there's been many, many lower court decisions in the United States, have all confirmed not just the illegality of the denial of Mr. Khadr's rights, but the fact that the U.S. is continuing to deny them. So what is Canada's duty, and how does that arise under international law? All of, as you know, it would be trite and a truism to say that there aren't any rights without any remedies. And all of international human rights imposes the duty of enforcement on domestic states. There is no international body that enforces either human rights or humanitarian law. Enforcement is completely dependent on domestic states. And to achieve that, many instruments require countries to prevent and punish outside their borders, as does the Convention Against Torture, and as do the all 4 Geneva Conventions, all of which have been ratified by Canada. Now, I'm sadly running terribly short of my time, so I'll stop right there. Well, on that note, I would like to say something to all of you other than to thank you again for coming. I just wanted to urge all of you to commit to doing good rather than making good as lawyers, that you're becoming lawyers in a very exciting and troubling time. And the legal community in Canada and the legal community internationally desperately needs people who are crazily committed to a peaceful and legal, but strategically smart and tireless fight for human rights and humanitarian law. Thank you very much.
Thank you, Gail.